Thank you so much, Scott, for that very warm introduction, and thank you all for having me. It's a real honor and privilege to be here with you all in talking about these issues of economic justice in the courts. I think it's a critical issue, and I think it's a critical issue for everyone in the court system, and thus especially this association, to be grappling with and to be working on, because there is a lot of work for us to do for us all to live up to the ideals that we hold dear when we think about what it means to have a fair and just criminal justice system. I'd like to start, though, by talking a little bit about the Southern Poverty Law Center, who we are, and a little bit of background on us before turning to kind of economic justice in the courts. As Scott mentioned, we are just up the road, a couple of hours up the road, in Montgomery, Alabama is where we're based. We were founded there in 1971 by Morris Dees and by Joe Levin. Now, Morris grew up in the cotton fields outside of Montgomery. And he was working alongside sharecroppers there in the cotton fields, eventually went to law school, is related to the Crimson Tide, went there. Joe Levin also went to Alabama for law school, and then ultimately went to the military, came back to Montgomery, and they both were starting their own practice. When they were doing that, this was around the time of the civil rights movement. There was much happening around them and involving them in everything that was taking place in the 50s and in the 60s. And of course, they had a front row seat to a lot of history and a lot of discrimination and bias that was happening, and a lot of need for justice that would need to take place to fix that. And in doing so, they decided to form the Southern Poverty Law Center to bring the organization forward as a nonprofit that would really be ideally working to fight back against those unfairnesses, against those biases, and really trying to create a more equal playing field for all, in particularly trying to fight against discrimination that was happening. I'm having a little problem with the slides in moving forward. What I might need to do is, if we can cue them just to tap forward as I indicate. Okay. There we go. Thank you. So this is Morris and Joe, who again founded the organization in 1971. Some of the early cases that we brought were explicitly about ending racial discrimination that was happening. In the lower left-hand corner is a picture of the YMCA in Montgomery. This was actually a case that Morris brought before founding SPLC in 1968 to integrate the YMCA and to make sure that its pools were accessible to all. Shortly after SPLC was formed, that tradition continued in a number of cases, including one case that sought to integrate the state police department in Alabama. And this went all the way up to the U.S. Supreme Court before it was resolved. But I think if we look back now at the history, it's particularly rewarding because the most recent person who was leading the Department of Public Safety, who recently retired as that organization was then folded into the now Alabama Law Enforcement Agency, he was actually one of the lead plaintiffs in the case, seeking to have justice for individuals who were going through that process and making sure that they were treated fairly and that race was not an issue in our state police department, which it certainly is not today. I think, though, probably what people think of most when they think of the history of the Southern Poverty Law Center is our fight against hate, and particularly our fight against the Klan. And it's particularly important to remember this, and a particular honor to be speaking here because of our history and connection with Mobile. In front of you is Beulah Mae Donald. Ms. Donald is the mother of Michael Donald. Michael was a young man. He was 19 in 1981. And he was going to the corner store, was doing nothing other than just going to pick up a couple of things when he encountered some members of the Klan in 1981. Now, a little background on this. The Klan at that time was a very strong organization, even in 1981. In particular, this was a branch of the Klan called United Klan of America. UKA had a outsized role in engaging in terrorism and violence against African Americans in Alabama in particular. It was these same individuals who would be involved in beating Freedom Riders in 1961 when they were riding buses trying to integrate our bus system. It was these same individuals who claimed credit for killing Viola Liuzzo when she was giving rides to individuals back and forth during the Selma to Montgomery March. And they also claim credit for bombing the 16th Street Baptist Church in Birmingham. These were folks who saw it as their mission to terrorize the African American community and to make sure that they would not feel trusted, that they would not feel that they were safe in Alabama. And that's what happened in 1981. There were individuals, the Klan, frankly, was outraged because earlier that day in Birmingham, a mixed-race jury had just acquitted an African-American man who had been accused of killing a white police officer. And they were looking for vengeance. They were looking for revenge, and they found Michael. And unfortunately, when they found him, simply because of his race, they lynched him. They lynched him right here in Mobile. Now, the criminal justice system quickly did the right thing. They found the two individuals who were responsible for this. There was a trial. They were convicted. But Beulah May looked at this and was outraged not only for the loss of her son, which could never be fixed, but also for the fact that the Klan had been doing this with relative impunity. Individuals might be challenged in the criminal justice system, but the Klan itself suffered no real repercussions for their activities. And so she spoke with Morris, and Morris agreed. They came up with a plan to file a civil lawsuit against the Klan to hold them responsible because they were ultimately the ones who were inspiring this activity. They were ultimately the ones who were inspiring this and encouraging people to engage in this type of terroristic activity. And so they received a judgment against the Klan, $7 million here in Mobile. And of course, Beulah May never saw that money. The Klan didn't have that money. But what it did have was property, a headquarters, which was taken away from them and converted into a park outside of Tuscaloosa. And also, it splintered the organization, such that it is a shell of what it once was. There are still chapters of the Klan, very localized, discrete chapters, but they are not what they once were with the coherent framework that they had. The Southern Poverty Law Center continued this tradition in going after other Klan groups and also bankrupting them as well. But for Beulah May, I think that it's fair to say for her, the critical thing was not only to seek some justice for her son, but also to say that enough was enough and that this wouldn't be tolerated going forward. And that has been the case. Many individuals will say that this was the final lynching, that there hasn't been another lynching since then. There have been other instances of violence sometimes with the Klan, but it's not what it was before. Mobile has named the location after Michael so that he will always be remembered. Michael Donald Avenue. Actually drove by there on my way in. It's only a couple of miles from here, and that's kind of the history and reminder of kind of where we're coming from and what we're doing. Of course, there's a lot of other work that SPLC has done. Those are just a couple of the cases. I'd be happy to talk with you all more about that during breaks or at other times. But I think it leads to really focusing on the work that we're continuing to try to do today. And so the short version of our motto is this: fighting hate, teaching tolerance, and seeking justice. And I think if you asked Morris and Joe today if we're continuing the work, they would say probably that they didn't anticipate the breadth and scope of the work that we're doing today, but certainly that it's part and parcel with their original vision of what the Southern Poverty Law Center is supposed to be. And so with Fighting Hate, we are continuing to do this through our intelligence project, both through the work in the courts that I just described with the Klan, but also through documenting hate and looking beyond just the Klan to other groups. Oftentimes, this involves working with police departments. So, for example, sovereign citizens is a particular type of extremism that has cropped up where individuals are really outraged against the government. And there has been violence perpetrated on police by these individuals, provide training to police officers so that they know what to expect and know what to look for and know how to handle those situations. We do a hate map where we document these groups groups. We zero it out every year and then start over and say what still exists and what needs to be done. Really, the purpose of our intelligence project is to document this and to publicize it so that people know what's happening and so that they can be aware of it and then put an end to it. The other critical part of our program is teaching tolerance. And teaching tolerance is really looking to the future. Teaching tolerance is about saying that our children are our future, and we need to, in our school system, be talking about race, be talking about differences, and be talking about tolerance so that we can get past these differences and really come to terms with it and come to terms with each other. And so we do this in a number of different ways. There are magazines that go out for free to all of the schools who want them. They have practicums that help teachers to talk about these tough issues and educate their children in a constructive and safe way. We also have produced a number of videos that talk about particular aspects. This is our version of Selma, Bridge to the Ballot. A little different than Oprah Winfrey's, but same name. Ours are usually much shorter. It's usually a 40-minute video, precisely so it can be shown in the classroom. This one in particular I really enjoyed because what they did was we went out and spoke to foot soldiers who were involved in the march from Selma to Montgomery, who are still with us today. Went and interviewed them, got their own words about what happened, what that experience was like, then had young children of today read those words for the film, and it's sort of a graphic series with drawings and such to really make it come alive and make it be impactful. This work is continuing, and I think really when we talk about it, this is the hopeful part of our work, really trying to make the world a better place. And then, of course, we have our legal department, of which I'm a part, which is Seeking Justice. And this has a number of different practice areas that we work in, including LGBT rights, immigrant justice, mass incarceration that's really focused on trying to rein in the explosive growth of our prison complex that we have seen since the 1970s. And then also children's rights that's focused particularly in the schools and what happens in the school setting, making sure that we don't have excessively problematic disciplinary procedures that are making it more difficult for children to succeed. Also looking at practicums and making sure that the schools are really training our children for the future. And then finally, our Economic Justice Project, of which I have the privilege of being a part, and which I'm here to talk a little bit more with you about today. So that's a little background on SBLC. I hope that that's helpful to put this all in context. But I want to switch next to talk about economic justice and economic justice in the courts and what that means to me. And I want to do this in a couple of ways. I'll start out by talking about kind of this current crisis that we're really seeing for what it is. The problem of what I'll refer to generally as modern-day debtors' prisons, and by that I mean individuals who are being jailed and put in custody simply because they were unable to pay. I'll talk about that and what we've seen, and talk about it through the story of one of our clients who has gone through this process. But I don't want to end there. Then I want to talk more about what this really means in terms of reform, the reform that's already starting, because there is reform happening. It's happening around us right now, and this is a very critical moment, I think, a real opportunity to be making a change and making a difference, and we're already seeing that start. And with that, I'd like to also make some recommendations of what we need to be taking into account and what you all need to be taking into account as you grapple with this in making economic justice a real reality in our court system. I think that the Supreme Court has long recognized the importance of treating individuals equally regardless of their economic status, making sure that our justice system is fair to everyone who goes through the justice system regardless of their wealth. And so Justice Black in Griffin said, there can be no equal justice where the kind of a trial a man gets depends on the amount of money he has. This concept has been reiterated consistently by the U.S. Supreme Court. So in Williams v. Illinois in 1970, you can't continue to incarcerate someone just because they're unable to pay their fines and costs when their sentence is over. Tate, the Supreme Court said, you can't convert a fine amount to a jail sentence simply because they're unable to pay. And then Bearden v. Georgia in 1983, the Supreme Court reiterated this again, saying that if someone comes before the court and is unable to pay, you may not incarcerate them without making an explicit finding that their non-payment was willful, that they were doing it intentionally, frankly, despite the court. Absent evidence of that, it would be inappropriate to be jailing them, because the only reason then that they would be being jailed is because of their inability to pay. The case law is clear. The guidance, at least at the highest level, is clear. And yet we see that in practice, these ideals are not always borne out in reality. And I think that we have witnessed at the Southern Poverty Law Center kind of a couple of ways that this has broken down. And one is what we refer to generally as kind of pay or stay sentences. And that is sentences where you go in front of a judge, the judge assesses a fine amount, no incarceration, just a fine amount, and then says, are you able to pay today? And if not, then the person is immediately transferred into jail or into custody. And usually what happens in these scenarios is the person is then incarcerated until they're able to come up with the money that they owe, or else they're given a credit per day that they spend in jail, and for each day that they serve, they get a credit toward the fine amount until it eventually is paid off. Another variation that we see on this, which frankly I think is more common, is a delayed pay or stay model, where again a person is assessed a fine amount initially and then comes back to the court at a later time, hasn't been able to pay it off, and at that point the court then will say, you've had as much time as you're going to get, you're now going to be put in custody again until either the money is paid off by some way, someone comes up with the money, or else that you serve out your time by converting, by giving you credit for each day you serve in the jail towards your fine amount. Making this worse is a concept that we've seen in Alabama and also particularly in the Southeast. I mean, I would say the pay or stay model that we've seen has been documented in locations throughout the country. This is not unique to the South. This is happening and has been documented as happening in not, I can't say every state, but certainly it's been documented in many states throughout the country. And really, I think, is continuing to happen precisely because we have judges who either aren't aware of this or don't know what they're supposed to be doing, or perhaps no one is just watching and no one knows. But an additional layer on top of that is pay-only probation, which this is something that we've seen being more specific in the Southeast. And what pay-only probation is so it's a private company usually that will be involved in a probation. The person will be sentenced to probation. But it's not what I think any of you in this room would think of as probation, certainly not what I think of as probation. When I think of probation, I assume that there's some effort to rehabilitate the individual, an effort to make sure that they're staying on the straight and narrow, an effort to make sure that they have every chance to succeed so that they won't recidivate, right? That's really the concept of probation. Get folks out of custody, make sure that everything is safe and secure, but also making sure that they have a chance to rehabilitate and so that we won't have them repeating the cycle and going back into the criminal justice system. But with pay-only probation, instead what we have is just payment plans. The only reason you're on probation is because you weren't able to pay your fine amount. There's nothing else that's happening in this system, except for one thing, which is that the people are being charged a supervision fee. So they're being charged a supervision fee solely for the privilege of being able to make a payment. And I think this is particularly perplexing to me because there isn't a better example in my mind of really creating a two-tiered system of justice. If you get a speeding ticket, as I unfortunately did about 6 months ago in Alabama, sorry about that, I got a fine and costs amount of $200. And I was, able to send a check into the court. I didn't have to appear. I wrote the check. I had to explain it to my wife and apologize to her. So I'm not saying that there were no consequences to me. But at the end of the day, I was able to write that check and go on with my life. Our bank account wasn't affected. I didn't have to make any decisions about what I would do without. I didn't have to make any decisions about food or nourishment or any concerns about our upcoming child. Life went on, right? But for individuals who are on this pay-only probation where they're paying a $40 supervision fee for a month, If it takes them 5 months to pay it off, then all of a sudden that same $200 ticket that I got becomes a $400 ticket. $200 toward the court for the fines and court costs, another $200, $40 a month times 5, going to this private company. And so literally it becomes more expensive if you are poor, and really makes it frustratingly true that it can be very expensive in our country to be poor. And this, in our perspective, really has no role or value in our justice system if we look at what our justice system is supposed to be achieving. And I'll talk a little bit more about that in a moment. But first, I'd like to introduce you to Ms. Harriet Cleveland. Ms. Cleveland is one of our clients, and I think that she, unfortunately, her story exemplifies all of these problems. Ms. Cleveland got a traffic ticket. She wasn't able to pay it all off. She was put on. She wasn't jailed immediately. She was given some time to pay, but wasn't able to pay it off. So then, at that point, her license was suspended without any notice to her. She then gets stopped in a series of license checkpoints that are set up by the police department, just doing license checkpoints outside of her community. And of course, then she continues to get more tickets because she's driving on a suspended license. That was the first time that she learned that her license was suspended, when she got stopped and when they said, your license is suspended. Now, Ms. Harriet will acknowledge she continued to break the law because she continued to drive. Now, she'll also say she had to because there's no meaningful public transportation in Montgomery. She had to get her children to school. She had to get herself to work. But she acknowledges she continued to violate the law because her license was suspended. She continued to get more traffic tickets because of that, and she continued to spiral further and further into debt because of the court debt. And so at one time when she went in on one of these tickets, the judge asked her if she could pay. She said no. He said, okay, you're going to go on a payment plan, talk to those folks. So she went over to the side of the courtroom and started talking to these individuals, not really knowing who they were, not really knowing what this was about. They told her that she would have a payment plan. She would owe $40 to them as a supervision fee, and that she'd be on probation with them with this $40, and that the rest would go back to the court. They told her she'd have to report monthly, but then as she wasn't able to keep up with those payments, it became weekly and then actually every couple of days that she would have to keep going in, and they would say to her each time, where is your money? You need to come up with the money. You're behind. And then ultimately would start saying as well, if you don't make these payments, then you're going to go to jail. Ms. Harriet did everything she could. She took out a title loan on her car and gave that money to them, and then ultimately lost the car. She lost her house due to foreclosure. She took her earned income tax credit that she got, which of course she only gets because of her low economic status, and turned all that money over to them, every dime of it, $2,000. By the time that she was done in giving them everything that she had paid over $1,000 to this company, and yet she still owed more money to the court. And finally she said, look, I'm out of work. There's nothing more I can do. And they said, well, if you don't have any money, you need to show up with the money and you need to bring the money in. So she finally stopped reporting. And that's when it went from bad to worse. And I'll let her tell you all a little bit more about that.
It was a Tuesday morning. My sister had just passed. We buried her that Saturday. So I was still feeling a little down and out. I had my grandbaby with me, and I was sitting up giving him breakfast that morning, and I heard a knock on the door. And I looked from around my room, because I was feeding him in the bedroom. We was watching cartoons, and I seen a police officer at my door. And in the back of my mind, it wasn't for me, because I didn't figure they'd come get you for tickets. I was escorted to jail. And when I went to court, the judge asked me, Miss Cleveland, why haven't you paid your tickets? I told him I didn't have the money to pay it. I can't afford it. I just got a new job. Can give me some time. He said no. So upstairs I went because I didn't have $1,700 to pay.
Now, I think what happened to Ms. Harriet was particularly perplexing and challenging to us for a couple of reasons. First of all, of course, she was ultimately jailed because she couldn't make those payments. But when she went in front of the judge, there was no inquiry into her ability to pay that was done, none at all. The judge said, "Why haven't you paid?" She said she didn't have the money, and that was the end of it. But actually, she said something else, right? She said, and she told the judge this, "I just got a job. Give me some more time. I'm now working again. I'll be able to pay." And the judge's response, unfortunately, was, no, that there's no more time that you can have, and so instead you're going to go to jail. And so again, this was a situation where every day you spend in custody, you get credit. So it was $50 a day for this town. That would have resulted in her, if she'd served it out, spending 31 days in jail because she couldn't pay these tickets. Not only 31 days in jail, though, right? I mean, what do you think happened to the job, right? She lost it. And so a situation where she's already on the brink of poverty is just made much, much worse because now her lifeline, her ability to get up on her feet, is further hampered and further interfered with by our justice system because there's no one taking that into account and no one was paying attention to that. Ultimately, with Ms. Harriet, we heard about this, we were able to get involved, we were able to get her out. She did serve a week in custody for non-payment. And we ended up, in her case, bringing an affirmative lawsuit. This is part of what I do, is to litigate. But as Scott said, I definitely do not think litigation is the answer. We need to be seeing reform, and we need real leadership in causing that reform. But in this case, we did sue. And quickly after we sued, there was talks of settlement and talks of new procedures that would be put in place in the court to make sure that this type of thing didn't happen again. And we were able to get there and get that done. There are a couple of key things I think were critical to that settlement that I'll talk about a little bit more detail later, but just really quickly right now. First of all, making sure, of course, that when someone comes back, that there is that inquiry. What happened? Why is it that you're not able to pay? But also to make sure that we have a payment plan in place that's meaningful and useful to the individual, something that they can actually achieve. Because it's not useful to say to someone, well, you have a $200 ticket, you can't pay it all today, and you need help. Well, here's a $140 a month payment plan. For some people, that might be okay. But if you can't pay $200, are you really going to be able to pay $140? So we need to be taking that into account. What is their actual ability to pay in economic status? And making sure that the payment plan is something that they can achieve so that we're setting them up for success, and ultimately we're setting our judicial system up for success to making sure that the system works fairly. The other thing that was put in place was the option for those who truly cannot pay to have the ability to do something else, community service, so that the justice system still has a method in place so that there is some punitive impact for the fact that laws were violated, but that someone who doesn't have the ability to pay, the only recourse isn't to have them serve out the time in jail. The other thing that happened as a result of that settlement, although we didn't directly deal with this in our lawsuit, was to end that company's involvement in these pay-only probation. And after that happened, we then said, well, this is happening to a lot of other individuals. Let's see what we can do about that. And so we brought another lawsuit, this time challenging the company directly, and saying that what the company was doing was itself exploitative, was itself really extorting money from individuals because the company was fully aware that people weren't able to pay. Ms. Harriet brought in proof that her house was being foreclosed upon, told them she lost her job. This was documented in the notes, and yet nothing happened other than them telling her that if she didn't pay, that she would go to jail. And so she had to at least come up with enough money to keep the probation company happy, at least enough money so that they would get their fees. And this we saw happen in other locations as well. So we brought a different lawsuit challenging that. I should note as well that we brought this lawsuit in 2015 in March. That date will be significant in a second. But we weren't the first. There had actually been a case in another town where a lawsuit was brought in state court, and the circuit court judge ultimately took over and shut down the municipal court because he said nothing is happening here other than exploitation, that this was effectively a judicially sanctioned extortion racket. So it was in this backdrop and context that all of this was happening, and definitely people were becoming more and more aware of this in Alabama. Well, shortly after we sued, the town where we sued immediately decided to cancel their contract with the company. When that happened, we were happy. That took care of the court. They also worked with us and others to put in place newer procedures, different procedures, to make sure that there weren't other problems, which I greatly appreciated them being willing to do to work with us, since the lawsuit really was only about JCS. But with that company, when this town canceled their contract, we said, well, maybe people aren't really aware of what's happening. And so we sent a letter to other towns where the same company was working. And I should say that Judicial Correction Services was the name of this company. They were, for lack of a better phrase, a dominant player in the market. They had a dominant position in market share in Alabama. At the time, at their peak, they were operating in 110 municipalities. And again, only doing this pay-only probation, where the only purpose of the probation was to collect fines and costs, and of course, their supervision fee. There are still, and were at that time, about 5 other companies that collectively at their peak were operating in about 36 locations, just to put it in a little bit of perspective. Well, after we sent letters to towns raising these issues, alerting them, and making sure that everyone knew what was happening, the towns said, wait, we didn't know about this, and so we don't want to continue this. We're going to unwind those contracts and stop this as well. And so by about October of this year, we had gone from 110 down to about 30. And then at that point, in October of last year, the company itself said, well, looking at what's happening, I won't put too much into their motives. I'll let them address that. But they sent a notice to the remaining 30 towns and said that they were pulling out completely from the state. And so at that point, this company is no longer operating in Alabama. There are 5 other companies that are still operating in Alabama, perhaps under slightly different circumstances. We think that they're operating still in about 20 municipalities within our state. Part of what this taught us, though, and I think part of what's critical in thinking about reform, is that there is this opportunity for individuals, when they become aware of it, to make the changes, right? And so much of what we focus on and what we always are trying to do in this reform space is to raise public awareness and to raise awareness with folks like you all, who I know you all are well-oriented on these issues, but to make sure that people realize both what's happening in practice in many locations so that they can do something to fix it. And before turning to reforms, I want to talk briefly about what I think really kind of gives rise to and incentivizes the possibility for the jailing of individuals because of their economic status. And that could be both because of the pay and stay fines that I've been talking about, but it also can be because of bail, which Scott mentioned in the outset, that I want to touch on briefly as well. But I think that, again, these things aren't, things I'm going to identify, they aren't a guarantee that you're going to have these problems. But they create an environment where there becomes an incentive, a structural incentive for judges to be engaging in these types of practices and really leading to the possibility that this type of exploitation will occur. Now, a lot of this is happening all over the place. The first thing I think that we see is offender-funded justice. And this is the idea that we have gotten to a point now where our criminal justice system is being expected to support itself, at least in significant part, by the individuals who are going through the system, right? And so room and board for jail happens in more than 40 states, that you're actually charging and assessing a dollar amount against individuals for every day they spend in jail, every day they spend in prison. So that when they come out of prison, they're going to have a very big IOU that they're going to receive when they walk out of the door. Probation and parole supervision, 44 states. Electronic monitoring, to the extent that electronic monitoring is part of probation, that usually, again, is assessed against the individual in 49 states. I actually should know which state it doesn't do that, and I don't. And then public defenders. Public defenders in 43 states, it's possible to assess that cost back upon the individual. And this one I want to spend a little bit more time talking about. You have, in order to get the public defender or the representation, right, it's not necessarily a public defender system. It could be a panel, which is very common in Alabama, that we don't have a statewide public defender system in Alabama. We do in some locations. Actually, that's starting to change now, which is good. But oftentimes, it's also a panel where someone will just be appointed and then get compensation from the court for their services. But that money then can be tacked on as a case cost at the end. Now, what's interesting from our perspective is you've already made a determination, the court has already made a determination in the first instance that the person is indigent. That's the only reason that they're getting public counsel, that they're getting a public defender in the first place. And yet, what never happens on the back end, and what must happen, well, I shouldn't say never, what we don't really see documented in the cases that we've looked at happening on the back end, is an assessment of whether or not that was a fraud, whether or not the person actually has the ability to pay. The American Bar Association, the ABA, has spoken out very strongly against the idea of assessing public defender costs on individuals who are going through the court, noting that the only time that they could see a reason for doing that would be if a fraud had happened in the initial application for the public defender, right? So someone misleads the court about their actual economic status. They could have paid for counsel, sure. I mean, they should obviously, I have no problem with saying those individuals should reimburse the state for the expense that it paid for providing that defense. But outside of that context, we've said this person can't pay, so now we're saying that actually they should pay. It might just take them a little longer. And respectfully, I think that that makes our obligation to provide counsel and the right to counsel ring a little hollow. But all of this is challenging because it creates a dynamic where the court is in part looking to the individuals going through it to pay for the system. And this then kind of bleeds into what I think people have been talking about a lot more right now, which is actual explicit revenue generation, which I think is a step further from what I was talking about initially. And two kind of reports to put this in context. I know you all are all very aware of the Department of Justice report with Ferguson and their observation that really, in the Ferguson law enforcement, the practices were shaped by the city's focus on money, and that bled over into the court system. And for those who are aware of this report but actually haven't read it, it's definitely worth a read. I mean, this wasn't a close call. There are emails back and forth from the finance director and from others saying we need to increase revenue, we need more tickets issued, and we need to make sure that our clearance rate in the court is up to snuff. It was explicit. Now, I think that's rare. I hope that's rare. I'm certainly not aware of other examples where it's quite like that. But I think that even if we look again at the pressure to fund our courts through this process, we see similar problems, even if it's not this explicit. So this is a report that was done very recently in Alabama in looking at Alabama courts. Now, in Alabama, that same $200 ticket that I got, the ticket itself was actually only $20. I was going over the speed limit. Thankfully, I was in the first year of going over the speed limit. So the fine amount was $20. The court costs that were tacked on made up the difference. And the thing about the court costs is, as problematic as it is to fund our court system in this way, in Alabama, and I think that this is probably typical of most other states, I just happen to know Alabama best, and this report was done about Alabama, much of that money is going to other agencies. And so in this sense, we're actually seeing the court operating as a method of a collection agency. As a collection agency in order to get money to go somewhere else. So for example, in Alabama, we have a court cost that is funded and targeted specifically for a revolutionary park, a location where one can go and see what life was like in the 1700s, and I'm sure I haven't gone. I probably will when our child is a little old, when our child is born is a little older, because I'm sure it's a great experience. But it's not an experience that we should be funding through our courts. Right? It's an experience that we should be funding, if we're going to fund it at all, through our general fund. And yet that's not happening. And when that doesn't happen, and when we have these incentives built in, then there's even more pressure to actually collect those court costs no matter what. And that creates the problem that we then have of what to do when someone can't afford to pay it. Bail is a huge issue. This is an issue that we have not done at the Southern Poverty Law Center any explicit work on yet, although that's likely going to change. But it is an area where we see a pervasive problem with people who are being held in custody simply because they cannot pay. And so this chart shows kind of the total picture of everyone who's incarcerated in the United States at any one particular time. And the upper right quadrant, of course, is in local jails. And so that's about a quarter of the total population. But then if we look within that at this number right here, 400,000 plus, that figure is the number of people who are in jail pre-adjudication. So these are folks who simply couldn't make bail. Now, this is particularly challenging when we think about fairness and economic justice, because for the majority of those folks, the vast majority of those folks, they couldn't make a financial bail. So if they had simply been richer, they could have bought their freedom while they were awaiting adjudication of their trial. And this matters. It matters not only for, putting them in jail matters, not only for the obvious immediate effects it would have on their family, on whether or not you're taking away a breadwinner, whether or not they're going to then lose that job, whether or not they're going to lose their housing when they get out, but also it affects the outcomes. It affects the outcomes of trials. Statistically, this is not a question. People are more likely to be convicted if they're incarcerated, and they're more likely to be sentenced to longer periods of time if they are incarcerated. What's interesting, I think, in this space is the reform that we have seen at the federal level, and the federal level isn't perfect, but there have been reform efforts at the federal level, and where we have seen that fall short at the state level. So at the federal level, what I'm referring to, of course, is the Bail Reform Act, which was passed in 1966, 50 years ago. And President Johnson signed that into law. He noted lots of things. The system, because of the bail system, he said when he signed the bill, the scales of justice have been weighed not with the fact or law nor mercy. They have been weighed with money. Because it's without the money, you're not going to be able to get out. But now, with the Bail Reform Act, we can begin to ensure that defendants are considered as individuals and not as dollar signs. Well, how is that? Well, it's because in the federal system, we don't have cash-only fixed bail systems, right? There's an actual inquiry into the particulars of the individual with a particular focus on what's the probability and what needs to be done to make sure that they return, and what risk, if any, they may be to the community or to themselves. But in the states, we still see, for the most part, the opposite. We still see fixed cash bail systems, at least at the outset, and then perhaps hopefully with a very meaningful inquiry later on, but it always follows. And there has been growing litigation around the country on this issue, because when you have a fixed cash bail system, you are explicitly saying, right, that the only thing that matters is your ability to pay. We're not concerned about the person's flight risk. We're not concerned about the risk to themselves or the risk to the community. And we know that we're not concerned about that because with a fixed cash bail system, all you have to do is have the money to pay, and no other questions are going to be asked. You're going to be released. If you don't have the money to pay, then you're going to be held. And so the Department of Justice has been particularly active in this space. There has been private litigation that has been happening across the country. And in a statement that they made, which was then largely echoed by the court in Georgia just recently, this year, so in January, I'll read what the DOJ says, and you can see how close the court followed it. Incarcerating individuals solely because of their inability to pay for their release, whether through the payment of fines, fees, or cash bond, violates the Equal Protection Clause of the 14th Amendment. So, I'm done beating up on people. Next, I'd like to talk, though, about what's happening? What are we doing to change this? And what's happening right now? And then what more needs to happen as we kind of continue this conversation and discussion to make sure that our justice system really is living up to the ideals that we want it to. In a perfect world, we're going to be in the bottom right corner. But we're getting there, actually. But where it has started is in the top left: litigation and settlements, lawsuits that are raising the profile of this, investigations that are happening that are leading to more focus being paid to it. But more focus is happening, and that's critically important and critically hopeful to me. So in December of this last year, the Department of Justice had a convening, and the White House had a day-long session on fines, fees, costs, and bail, and what can be done about it, what needs to happen in this space. I'm going to come back to that a little bit more at the end, but I emphasize this to say people are paying attention. It's a conversation that's happening. You all know this. You all are hearing this conversation, and hopefully you all are involved in this conversation. The other really exciting thing that was just announced, which I hope people in this room know, but if you don't know it yet, you certainly will hear more about it as this moves forward, is that there has been a task force that has been convened by the Conference of Chief Justices and also by the Conference of State Court Administrators that's specifically seeking to tackle this issue of what do we do about fines, fees, and costs? What do we do, in my words, to make sure that our justice system is living up to its ideals when we're encountering individuals who are unable to pay? And that, in my mind, is incredibly heartening and incredibly important, because that's what's going to allow us to then get to the bottom right corner, where we're seeing reform happen through the people who are in the process themselves, who are really grappling with this, so that they can say, oh, this is how we can do it differently, this is how we can do it better, and we have the personal know-how and experience to make sure that this is practical both for the courts and also continuing to respect and honor the rights of the folks who are going through it. And look, these voluntary reforms are happening right now, right? California passed a statute a year ago, last year, that would allow individuals to get their driver's license back and would allow individuals to get on a low payment plan based on their income. Various municipalities are starting to grapple with this, creating some amnesty periods, also creating a process to get driver's licenses back. The driver's license issue is really critical because, from my perspective, and I'll talk a little bit more about that in a second, when you take away someone's license, you are really making it very difficult for them to succeed. And so that should only be done in the worst of situations where someone is really willfully not paying. Because if they're not paying through no fault of their own, taking their license away simply makes the whole situation worse for them and worse for the courts. But before talking about specifics, I want to touch on a few kind of bigger pictures and frankly, a challenge to you all. And I want to start with the concept of procedural fairness. I'll touch on this only briefly. I think you all know this probably better than I do. But Scott referenced this in the introduction, and I think this is really critically important. Procedural fairness, and just from one article, and this came from Judge Steve Lieben of the Kansas Court of Appeals. He noted that the critical thing about procedural fairness is an observation that individuals are going to judge and assess our justice system not so much based on, or maybe not at all based on, the actual outcome, the actual sentence that they get, but rather how they are treated during the process and what their perception is about whether they are treated fairly, whether or not what's happening to them is equivalent to what would happen to others. And so in this report, in this sense, Judge Lieben notes that there's an incredible opportunity here to make sure that the courts can enshrine and enhance their own integrity by looking to this and thinking about, well, what does this really mean? And I think there are generally four concepts. This was his articulation, again, giving fair due where it is owed. But I don't think this is unique, that folks talk about this in terms of voice, neutrality, respect, and trust. Voice being the idea that the individual going through the process has to be able to engage and with the process, has to be able to be heard, has to have their questions answered, but also has to have the ability to say what they think is happening and if they think that anything is concerning them about the process. This, I'm sure in this room, is taken as a given. And yet what we sometimes have seen is more of a streamlined system of justice, a system where it really seems that the process is there just in place to make sure that the person appeared in front of the judge so that then we can get on, assess the fine, and then get to the next case. Neutrality is, of course, critically important. I think that speaks for itself, but making sure that you're consistently applying legal principles, unbiased decision makers, and transparency. The transparency is critical in my mind in making this work. If you want people to think that they're being treated fairly, then you have to explain to them what's happening, because without them understanding what's happening to them, they only have their one unique experience, right? They don't have an opportunity to see what's happening in every other case. They don't have an opportunity, if they don't have an opportunity to really understand the decision-making process, then that will create the environment and space for them to assume that what happened to them was unfair to them. And so by being transparent about the entire process, you help to undercut that by showing, look, this is what's happening and this is why it's happening. Respect is critical. The individuals are treated with dignity and their rights are explicitly protected. I think, again, this is something that no one would disagree with. But I think that the one thing that I want to emphasize on respect is really making sure that a person's rights are explicitly acknowledged and frankly discussed. It's not enough to just not violate someone's rights. Because if they don't understand what their rights are, then they don't understand the whole process in what's taking place, and they don't have any, they're not going to, or at least it's going to be less likely that they're going to have any faith in what happened to them. The rights have to be explicitly acknowledged and dealt with, and so that the person knows, these are my rights, and this is why this process isn't violating them. And trust, I mean, ultimately, I think all of the precursors lead to trust. It leads to a process whereby we're going to have a system that people can believe that they're being treated fairly in it and that they're not being taken advantage of for whatever reason. But the second thing I think that's critical here, and again, all of that has been talked about for some time. I'm not adding anything new to that conversation, is that I want to challenge us to think about economic justice in this context. And that really, for our justice system to be fair, that we have to be taking into account the ability of the person to pay when we are assessing fines and costs. Because if we do not do that, then our system is not fair. And I want to pause on that, because this is, and I get some pushback on this, and I'd appreciate some pushback from you all. This is a discussion. Or at least it will be, and if not right now, we'll take some questions at the end if we have time, but certainly in the breakout session this afternoon, then it will definitely be a discussion. A lot of judges will say to me, and I've talked to judges about this, well, the fine amount is the fine amount no matter who you are. And that's fair. That's one version of equality, right? But if we take a step back and ask ourselves, what's the purpose of the fine? Why are we assessing it? And I think that if we think about that, the answers are that we're assessing it to have a punitive impact on the person, and to give them an incentive to deter, right? To give them an incentive to not violate that social compact again in the future. But if you think about it from that perspective, punishment and deterrence, then the economic status of the person is critical to understand. If you have a $200 fine and you're at the poverty level, then that means that $200 fine is 20% of your monthly income. Now, we might want to calibrate that. I mean, that might be fine. But the relative point here is, what if you have more money? What does that same fine look like, right? So if you're at $50,000, then that's going to be about 5% of your monthly income. And if you're at $100,000, it's going to be about 2% of your monthly income. And this matters, because if we are seeking to punish and if we are seeking to deter, then the whole reason that we have fines is to cause a little sting. But the sting should be consistent regardless of your economic level, because asking one person to pay 20% of their income toward the fines and another person to pay 2% of their income towards the fines speaks to the relative sting that it's actually having, and speaks to whether or not the system is actually treating these two people fairly, even though they're both getting a $200 fine amount. And I would note as well that this really matters because there are a lot of individuals. I mean, we all know about economic disparity in our country. That's nothing new. But in Alabama, for example, 20% of adults are living below the federal poverty line, 20%. And the federal poverty line has its critics. Is this a really good way of measuring? It was formed in, I think, the 1970s, a breadbasket, back then. The FPL is supposed to take into consideration the total amount of money that you would need to expend to make sure that you have a fair and balanced diet and to make sure that you're taking care of your other basic necessities. I mean, we can argue about whether FPL is the right model, is the right standard. But the idea that there is a standard, I think, shouldn't be controversial. And the idea that, and the reality that, at least under the standard that is the most widespread right now, 20% of Alabamians and national figures actually don't have, but I believe are in the mid-50s, I believe are between 10 and 20. Alabama's higher than average, shows that this is not a rare problem. This is a problem that the courts are going to be dealing with on a frequent basis, individuals who are coming in front of them and who don't have the ability to pay. But what would this look like in reality, right? Well, so right now, this is kind of our typical structure, right? Our fines are going to be increasing based on the severity of the crime. The more significant the crime, the larger fine amount that's going to be assessed. And this, I would posit, is what we need to get to. A situation where we're taking into consideration both the severity of the crime and the ability of the person to pay. Now, this is very different from how we do it right now, but it's not actually that foreign of a concept, even though where you really see this type of a model happening is across the lake in Europe. There have been test studies where this has been done in the United States. Maricopa County, a test case was done on this in the 1980s by the Vera Institute, and the Bureau for Judicial Assistance was involved in that as well. And they found this to be successful. But if we look even in our rules of criminal procedure, it's very common that you'll have something like this, and I'm going to quote from Alabama. Alabama Rule of Criminal Procedure 2611, imposition of fine. When assessing, the court should consider the financial resources and obligations of the defendant, the burden the payment of a fine will impose, and the ability of the defendant to pay the fine. We already have this in our rules, and I would submit that, although I quoted you from Alabama, that's not unique. You're going to see that in the rules of criminal procedure in other states as well. And yet we don't do this. I'd submit that we don't do this. If people are doing this, I want to hear more about it. The other thing that we have to be doing is, again, tackling our fees and costs. The CCJ and the Conference of State Court Administrators have articulated their position very strongly on this, that the operating fund for the court has to come from the general fund. And yet, in reality, we know that that's not happening. And that needs to change, because we should not be tacking on these additional funding revenues as part of the fine. If we want to assess that as a fine penalty, if that's our decision, that the speeding ticket actually should cost me $200, that's okay, we can do that. But we should say that's the fine amount, not that the fine amount is $20 and the rest is court costs. Of course, I appreciate easier said than done, and that's not the decision of anyone here in the room, much as you all probably wish that it were. But even if we're not going to get to a point where our courts are funded strictly from the general fund, we have to have protections in place to deal with individuals who aren't then able to pay off these court costs. We do this in the civil side, right? We have processes in place all the time that when someone is low income and they need to file a civil suit, they're able to do so. We have an informa pauperis process, right? They'll submit some form of an affidavit of substantial hardship to show that they can't pay it. They'll be allowed to proceed with their civil case. We need to have similar protections on the criminal side. If you can't afford to pay, those costs and those fees need to be able to be remitted. In practice, that becomes very challenging, again, for the same reason, because that is the funding source for far too many things. But again, in reality, if we look at the rules and the principles of what we're supposed to be adhering to, in the Alabama rules, again, in 2611, it's subparagraph H, it says that a court may cancel out and may remit those fines and court costs and fees if the person is unable to pay. And yet, in practice, we don't really see that happening. There need to be fair and clear and objective procedures. Part of this is, frankly, about a payment plan. I think we talk a lot about indigency. I think that's very important. But really, on the back end and the payment plan, that's where, to some extent, when we're talking about fines and costs, the rubber meets the road, because whether they're indigent or not, whatever that term will mean in any specific context, if they aren't able to afford the payment plan, they're not going to succeed. We've seen this a couple of different ways that's been done. So in Alabama, certain courts have started to say 125% of the federal poverty level is our statutory definition for a presumption of indigency. You can be found indigent if you're higher than that, but you have a presumption if you're at or below 125% of the FPL. So we'll create a bright line rule at that point and say this is your payment plan of $25, something quick and easy. Florida, I think, gets at it a little bit more scientifically. They say, look, your payment plan may not exceed 2% of your net income. So whatever your income is going to drive then what the maximum payment plan is going to be, precisely because that's taking into account what you can afford. There needs to be alternative options for individuals who cannot pay. There are going to be some individuals who simply are unable to pay, and frankly, those are the individuals who are going to be in front of the judges. Those are going to be the individuals who you're going to see, because if you're able to pay, you're probably just paying it off and not going in front of the court. And there needs to be a limited time for how long these payment plans continue. Again, from the punitive impact of all this, unless we're calibrating the fines and costs on the front end to the actual person's net worth, then we ought to be saying on the back end, look, you've been compliant for 12 months, you've been making the payment plans that we agreed, you're done. The only thing we're talking about here are fines and costs. There's no benefit to anyone, except for to the budget, to continue having them pay and to continue having them be required to make these payments when it's also then cutting into whatever else they could be expending the money on to stand up on their own 2 feet. I haven't seen anyone do this, but I do submit that this is also something that has to be considered, because otherwise you're just stringing the person out for an extended period of time. You gave them a smaller payment, that's great, but now they have this debt for the next 2 years of their lives. That is inhibiting their ability to stand up and, frankly, their ability to contribute to society. And it's not enhancing either the punitive effect or the deterrent effect that I referenced as really, I think, kind of the pinnacle parts of what we're trying to achieve. And driver's licenses. I referenced this before. From our perspective, most states authorize suspension of driver's licenses with no discussion of ability to pay. I'd submit, there hasn't been a court that's ruled on this yet. But if you are taking away someone's driving privileges without doing a determination of why they weren't able to pay, then the court is engaging, again, in a disparate process precisely because of economic status. Now, if someone is not paying because they are willful, they're intentionally doing this to the court, then I have no problem with suspending their driving privileges, because then we're seeing it for what it is. It's a punishment. It's a technique to try to coerce the person into making good on the payments that they have the ability to pay and they're just choosing not to do so. And frankly, it's a step below jailing them, right? We're going to suspend your license first. If you still don't comply, then the court might decide if it needs to take further action. But for individuals who, where you don't do that inquiry, and so for individuals who there's no reason to believe that they're not paying other than just their inability to pay, then not only is it bad law because you're treating them differently, it's frankly just terrible, terrible policy. These individuals, what we want them to do is to have the ability to pay. We want them to be able to succeed in society. We want them to be able to get ahead. And the only way to do that is by continuing to facilitate their ability and process to engage in society, to go to that job. Ms. Harriet, at the end, when she finally stopped driving because she knew it wasn't lawful. She didn't know what else to do, but she finally stopped driving. So then she started walking 6 miles each way in the Alabama heat to her daycare job. Now, you all are here in February. This isn't quite the experience of what it is in July or August, right? It's just not serving any purpose. And for that reason, I think we need to recalibrate that because it has fallen into an almost de facto thing that we see happen. And then with bail, I think, again, if we look at, this is a challenging thing for a lot of folks. If they haven't thought about this a lot, I think it can be challenging. It was to me when I first thought about it. But we need to take away our cash bail system when we have a fixed cash bail system because it's not serving any of the purposes that we are seeking out and setting out to do. Again, the only legitimate purpose that we've identified for bail is to make sure the person shows up and to make sure that the person isn't a risk to themselves or to the community. But if we have a fixed cash bail system, we're not doing that inquiry. And if we're not doing that inquiry, then we can't say that the fixed cash bail system is serving those ends. And instead what we have is a system where if you can afford to buy your way out, you will be set free. And if you cannot, then you're going to remain in jail. Now, this has been an area where, again, we're starting to see very interesting reform at the state level. There has been litigation in this area at the state court system, particularly in the municipal courts, where we're only dealing with fines and costs, usually from traffic tickets, but possibly also from municipal ordinance violations. And we are seeing in that space a change that courts in Alabama in particular, but also in other locations, municipal courts, are starting to say, okay, this seems fair. Let's try instead doing a signature bond, where we will release the person instead, informing them that they have to come back. But we'll release them on a signature bond where they will then owe the money that is due if they don't show up. But otherwise, they're free and clear to leave immediately. And I would say that statistically, we haven't had enough time to see what's happening in those municipalities in terms of return rates. But if you look at Washington, D.C., where they don't use any sort of a cash bail system, their rates are consistently along with national averages and what you would expect in terms of people returning. In fact, I think they usually beat the national averages. And if we do have a system where someone is not going to be released, then of course what we need to do is make sure that they get a timely, probative, individualized hearing. And again, this is straight from the case law, straight from the statutes, straight from the rules. I don't think there's any controversy about that. But I think that the challenge is we have often seen slippage on this, particularly when we're dealing with courts that are only in session maybe once every week or 2 weeks. The judge might be only part-time. Usually, again, this is an issue that all we have to do is call someone and say, this is what we understand is happening, and then they figure out a way to fix it, which is good. Because again, I don't think there's any controversy on this, but it is an area where we're seeing some slippage and we're seeing some failings. Now, I know that this is a lot, and it's going to be an ongoing conversation that needs to continue to happen, because there are sometimes easy answers, but not always. And much of this is really going to be complicated because we also, of course, have to make sure that our justice system is working smoothly and efficiently as well, while still respecting the rights of the individuals going through it. And I think that the challenge that I have for myself and for everyone who's grappling with this is that unless we deal with this, unless we really get to a position where our court system is taking into consideration the person's ability to pay when they're dealing with fines and costs, we really are going to continue to have a perpetual two-tiered system of justice, where it does really matter what type of justice you get based on your income level. And so, I want to close by referring back to that Department of Justice session in the White House panel, the day-long plenary that happened in December. Attorney General Loretta Lynch spoke at that event, and I think that her words, I can't put them better, so I'm simply going to share them with you. She started out her remarks by saying, by asking the question, what is the price of justice? And then she concluded, what is the price of justice? Let me now point out the fundamental error in the question I posed is that it is a question at all. The fundamental error of the question is thinking of justice as a commodity that can be quantified, rather than a right inherent to all who stand under the sheltering arm of our Constitution. Because to reduce the essential ideal, this precious idea, to try to reduce this idea to mere coin, is an effort not only doomed to fail, but ultimately an effort that cheapens us all. Thank you so much for your time and your consideration today. It was a pleasure to be here with you.